Welcome to the Groth Gets It podcast. We're here with one of our law clerks to talk about whatever our law clerk wants to talk about. So this should be an interesting podcast for that because it's all up to Nathan here. So we're going to start the podcast like we start depositions. Please say your name and spell your last name for the record, and then we can begin.
Yeah, absolutely. I am Nathan Wlodarski. That last name is going to be Wlodarski. And I've got a vertical slice of questions here. I'm happy to hop on whenever you're ready.
I want to ask a question, though. How many times has somebody gotten your name spelled correctly on the first try?
Never. It's almost never. I think you rarely get someone who's kind of into Polish culture and knows those linguistics who knows that the L is silent, but it's always Wlodarski, and it's always, they try and either leave the L out, or if I don't tell them that the L is silent, they pronounce it Wlodarski.
Yeah.
It's almost zero.
Is there a lot of Y versus I issue?
Yeah, I mean, the entire pronunciation is different for the kind of the Slavic languages, but the L is, no one gets that. That's going to be tough. But there's a lot of skis and walkies, so it's not entirely out of that you get someone who knows Polish.
Well, I think in just our Midwestern corridor, right? Milwaukee, sure. Chicago. Mm-hmm. Interesting. All right, sorry. I messed up. I should not have asked the first question, but I did. But it's my podcast, so I can.
I'm happy to be interviewed.
It's up to you. What questions do you have of me?
All right, yeah. Well, starting out, as I understand it, you were also a law clerk, same as me, in law school. I wanted to ask, when you were clerking in law school, was this at a personal injury firm?
No. My first clerkship was, now I got to go back on my, yes, my first clerkship was at a personal injury law firm in Illinois. Waukegan and Chicago is where they had their offices. The Selvey Shostak law firm, and then it at the end of my time there, it became Selvey Shostak and Pritchard. But I clerked there for, in essence, I'll say maybe a couple summers-ish. Then I clerked after that for a general practice law firm in Waukesha called Myrn and Martin. Okay. And there, it was not just personal injury, it was general practice. My goal with that was to do anything litigation-wise. I had taken a lot of trial ad, pre-trial and trial ad type classes, and I decided that was kind of how I wanted to get my feet wet, was in trial work, knowing I liked personal injury, knowing I liked my classes, and luckily Myrna Martin gave me opportunity to do a lot of, I don't want to say crazy stuff, but a lot of interesting stuff where
sure.
Small claims trials, small claims, whatever, collections, evictions, large claims, invasion of privacy, bunch of depositions. I think I graduated May 22nd, maybe, and then May 23rd, I was taking a deposition of a fact witness in a case. It was that kind of experience. So to answer your question, first law clerkship was personal injury. Second law clerkship was a general practice firm.
Do you feel those trial ad courses in law school and kind of that experience with litigation in that clerkship is what pushed you towards PI, or did you have some innate desire to do PI outside of that?
Did I have an innate desire to do PI? I went to law school with the thought that I would be like a district attorney or do like some criminal law. And then I took criminal law with Professor Hammer and said, nope,
okay,
not going to do that. And then I wanted to do international law, and I studied for a while in Japan with Professor Port through a program in, I think, Loyola, New Orleans. Professor Rosen, I think was his name.
This was study abroad at Marquette?
This was study abroad.
Oh, cool.
At Marquette,
yeah.
Through Loyola, New Orleans, and at Toshisha University in Kyoto, Japan, which I can kind of remember some of the things I learned. There was a lot of karaoke involved, a lot of sushi.
Classic.
And I think I can count to 10. Ichi ni sanshi ro. No, ichi ni sanshi. Kyuju. I can't remember, but I used to be able to count to 10. And then some other words like bakigajin and sumimasen. I think sumimasen means like excuse me. But anyway, so I did international type law was kind of the goal. Came back, took classes with Professor Waxman. I think I had a couple classes with him. I'm assuming he's long gone from Marquette. And then decided that was not for me because I didn't speak any foreign languages. I took Latin in high school, so I didn't speak anything. And decided that was not going to be for me. And then because of my personal injury experience, like, well, I did like that. I enjoyed just kind of understanding tort law. Took some tort classes, took trial ad, and I was like, oh, I like this a lot. And that's what got me into wanting to do trial work, not knowing if it was personal injury or not, just trial work.
Sure.
And then when I got the clerkship with Myrna Martin, then I got a job with Myrna Martin, and then from Myrna Martin, I eventually got poached to a personal injury firm downtown, and that's when I got into personal injury law exclusively, and have been doing that ever since.
Cool, thank you. When you were clerking, do you feel that there was something you learned on an on-site clerkship that you feel law school completely misses or doesn't really cover?
Boy, I think there's a lot that law school completely misses and doesn't cover. I think I'll say the maybe not the monotony, because that might just be how today is feeling for me, but the monotony of meetings and the organization. I mean, you kind of think, well, I'm going to go practice law, but then you don't realize that law is a business and you have to run your law firm like a business. And that I don't think is taught in law school.
Sure.
There was one class that I was lucky enough to take. It was very, very broad. It was called, I think, How to Start and Manage a Law Firm.
I think we still offer. I'm probably in that next semester. It's called Solos and Small Law Firms.
It was called something different when I was there.
I'm sure it evolved, but it seems like that might still be a lesson offered.
It was more like the business of running a law firm.
Okay, sure.
So, I mean, we talked about getting a checkbook.
Yeah.
Should you advertise? That kind of stuff. Can you advertise? Health insurance, just very basic things, and writing a business plan, those kind of things. So that's something I think that was something certainly that I was aware of, but not to the extent that going to a law firm and seeing as a law clerk that we had these meetings and the way different people interacted was different.
Sure.
Like, for example, the interaction example at a law firm that I worked for, it was, I'll say nicely, discouraged for paralegals to talk to lawyers. I wasn't kind of ready for that. It's like, well, we're all humans. Why can't we talk to each other? And when I went, I thought I was being nice. I was like, well, hey, let's go to lunch. And I came back from lunch and was brought into one of the partners' offices saying, what are you doing? You're going to be a lawyer. You don't do that. I'm like, okay, well, I thought I was just being nice.
Yeah, how do you effectively work with your,
with your
team then?
But those kind of things, I learned kind of the politics of law from my clerkship as opposed to law school.
Okay, cool. Thank you. Now, as the story goes, you inevitably went on to, obviously start your own firm here with Groth.
Yep.
And certainly there's a lot to be said about the trials and tribulations of taking that risk to jump and hang shingle. Was there kind of a scariest 90-day portion where it was, really a struggle to steady the ship, or did you think it was a pretty smooth transition from moving out of the safety of an established firm?
Give me a break. That's a terrible question because the answer certainly is.
Yeah. I want to hear the story. What's the anxieties that come with that?
For the past 16 years have been a scary portion. No, but great question. I think it was a very difficult first 90 days because we didn't. I mean, we're in personal injury, so you never know if and when you're going to settle a case. You don't know even when you settle the case when you're going to get paid from an insurance company because they could say the check's in the mail and literally it's not in the mail for a month. And then when you call them and say, where's the check? They're like, oh, we mailed it to the wrong address or it's here, wherever, and we don't get it. So that's a concern. Sorry, the phone's ringing. I should probably turn my phone off. This is when you're doing it live, like O'Reilly, we'll do it live. You have those conditions. Live. Yeah, we'll do it live. All right, so that was very stressful because you really didn't know what's what. So I think I said this before on other podcasts that we just borrowed as much money as we could, just had as much money available, drained whatever accounts we could to make sure that we could survive. I mean, I had at that point a child who was 5 and a child who was 2 and would soon have a child that was going to be born. So yeah, we were in the thick of
and that's definitely what I
chaos.
Read a lot about. It's really tough to take that risk, especially when you're at a point in your life where it's generally not advised to take that risk.
Mm-hmm. Well, and you had certainty, right? You had certainty that I'm getting a paycheck every 2 weeks. I know that it would happen. Now, with great risks come potentially great rewards, and luckily that was the case.
How long do you think it took before you could take that first exhale and say, there's a business here that we can succeed with?
Yeah, I think maybe certainly within the first year, it was like, okay, something's happening, because I had 30-ish cases when I first started, and no staff. It was just me in the basement. Molly, our dog, was walking overhead. Our sons were crawling or walking overhead. And I was meeting with clients at a HQ or Regis, like a WeWork kind of temporary workstation. So I looked legitimate. And I would go to other law firms and use their conference rooms, and I was the trial lawyer that they would bring in. So it was their client, but they used me to do the trial work. So when I had those cases and I had some certainty there, then within 6 months to a year, we started getting a lot more cases, and it was from 30 to 60 to 90 to 100. And that's like, oh man, I need additional help. Yeah. And then I hired a part-time paralegal, and then I hired a law clerk, and then I hired a part-time bookkeeper, and then it just kind of snowballed from there as more and more cases came in. And I was not ready to scale. It was that was even probably more difficult because now I had to have income on a regular basis to pay for the salaries.
Yeah, you've got overhead, right?
All the overhead that people were relying on me, and then it was odd, and it really didn't change until, pardon me, at some point, with all the books and podcasts and such that I was reading and listening to, where you change your mindset from working in the business to working on the business. Sure. That switch was flipped, and then things kind of took off to where we are today.
Yeah, you start to be able to, trust your team to deal with that work, and you can focus on the more big picture. Sure.
Yep.
Is there something you wish you could have told John 16 years ago when you were first starting, knowing what you know now?
Yeah, well, not to be so nervous that it'll work out, and probably invest in people faster, probably. But I think we tried to do things as good as we could at the time. Sure. There just was a lot of uncertainty because it's a personal injury practice, and but probably just invest in people sooner, and maybe go back to this: create processes that are complete and thorough ASAP. So you have those in place So then scaling is so much easier. And that's something that we still are working on. Every single day we're trying to figure out what a better process is for whatever we do.
Yeah, absolutely. I wanted to jump into some more kind of courtroom specific questions.
Sure.
As I understand it, you have argued in front of the Wisconsin Supreme Court twice.
Correct.
What was that process like? Is preparing an argument for 7 justices, significantly more anxiety inducing than 12 jurors?
So the first time, I think that maybe the second time, well, one of the times, there was a Caribou Coffee on the corner of Highway 100 and Blue Mound Road. And I would wake up in the morning, probably, 5 o'clock or something, and drive there and work on my stuff, you know. And then I would go to the office, do my regular work for all my other cases, and then go to another coffee shop or go to a library or whatever and work on that case again, and then go home. So it really, it's like a whole part-time job. At least for me, it was a part-time job because you have to know every case that you can imagine related to that underlying fact scenario. And I had binders, I don't have any in here that look like it. I had binders that were, 6-inch binders full of cases that, if the justices had a question about X topic, I had it tabbed, and I could go there as I'm talking to, Judge Abramson or whomever. I could look her in the eye. She asked me a topic I would know in general, look down quick, open the tab, quick synopsis, IRAC or whatever.
Yeah,
what
your outline.
said.
That's what it sounds like.
Yeah, and then go from there. And that was difficult because it was literally maybe months, but certainly weeks of my life that was overturned, over-ended, messed up in a good way, because it was just that was how you had to do things. You had to prepare for this monumental case in those 2 scenarios. And the one case was I'm trying to think what year, maybe 2002. So it was before I had kids. So that one was quote unquote easier.
Okay.
Because I didn't have to worry about coming home and, relieving my wife from dealing with my crying baby son or whatever. And then the second case that I argued, we had a son, because I remember we had Jim, because my wife had him in like a baby Bjorn type thing.
Yeah, sure.
And she came to the argument with my parents to watch me argue, and he was there. I don't think he cried. I think he was a good baby and watched it. So in theory, he watched that argument. But that case was different because then you have a whole nother, your life continues on, and you have a whole nother person to try to help out with at the same time dealing with your caseload, and at the same time getting ready for that Supreme Court argument. So, and our firm was not a huge firm.
Yeah.
We had, I'm not going to say their name, but I'll just say, I think at that point we had maybe 4 attorneys and maybe 4 or 5 staff, maybe.
Okay.
So there was nobody that was doing the work for me. It was my work. I was the clerk. I was the paralegal. I was the attorney, certainly.
Yeah. You get familiar with the case
and
that way.
And you know everything, right?
Yeah, absolutely.
Yeah.
I know that you have taught a lot of other attorneys PI law. Certainly you've had a number of other lawyers, here that you work with on a regular basis. Do you feel that there is something that young lawyers get consistently wrong about PI law when they're first starting out? Like, is there a trend you see that you constantly have to correct in these young lawyers?
I think, well, I don't want to call anybody out, but I think one of the things you have to look at is just the general phrase of resisting the urge to be reasonable.
Okay.
So you are an advocate for your clients, and from time to time I'll ask, which I haven't done this yet with you guys, but I'll ask law clerks, what's the value of this case, or what do you think about this case? And maybe because of overthinking or the insurance companies, commercials or TV shows or society in general, how they've bent minds to think more towards an insurance company versus for a plaintiff. That I think is something I see more often than not. And it goes back to you have to resist the urge to be reasonable to properly advocate for your clients. Like one thing, for example, I know I'm going to ruin it because I can't ask you this question, or hopefully the other law clerks won't watch this before we do this, because I'll ask them that, let's say you're involved in a car crash and you are rear-ended by somebody else. Okay, what percentage are you responsible for the crash? Is it 5-10% because you're on the road? What do you think?
I was rear-ended?
Yeah.
If I was driving safely, I would argue 0%.
Okay,
right?
well, good answer. So I was trying to influence the answer by saying 5 or 10%, but many times people will say, well, yeah, you're 5% responsible just because you're on the road.
Yeah.
And I've had multiple law clerks who have just said that.
Mm-hmm.
That's not the case. But that's where I think getting a law clerk and new lawyers to really fully understand that you have to resist the urge to be unreasonable.
Yeah. Okay.
Resist the urge to be reasonable and be totally unreasonable to be a good advocate for your client. That
Sure.
I think is something we have to watch out. Well, because in law school, you're trying to know both sides of the story. You're trying to, you're tested on, like in mediation class, whatever, trying to understand what they're doing, and maybe the next week you'll be the other side.
Yeah.
Well, in this case, you totally have to be, because you're only going to be for the victim.
Sure. I guess kind of going off that, when you're looking at these cases, what is the flags you're looking for early that tell you this is a case that should settle or this is a case that should go to trial?
Oh boy, I think in every case you have to prepare like you're going to trial.
Okay.
The only difference would be is if there is a horrible situation, meaning really bad injuries, no assets, or the other party has no insurance, and you're stuck with your client's uninsured motorist coverage, and it's limited to X amount. That's really a time that you're not going to go to trial. All you can do is try to make the best of a bad situation and maximize the amount of money that your client's going to get, because it's going to be limited. Those are really the only times that I would say you don't prepare like you're going to trial.
Sure. Cool. Any attorney who tries a lot of cases is you're not going to go unscathed. There's going to be winners and there's going to be losers. Do you remember a case that you lost that taught you a significant lesson that you've taken forward into other cases?
Yeah. Whenever I'm asked that question, I had a case where I think her first name was Tiffany. It's probably wrong. I'm probably wrong about that. But I still am mad about it because I lost. But I'm mad about it because afterwards the jury said that the reason they found in favor of the defense was because my client did not have pictures of where she fell. We had testimony from the market at which she fell that there was water on the floor that the owner knew about and didn't clean up. We had testimony from the ambulance, the EMTs who came in, who said there was water on the floor when they helped my client up. And somebody, I don't remember who, described the size of the water puddle. I mean, the puddle was a big puddle. So it was there. They were aware of it. They didn't do anything about it. In my opinion, that's negligence. But because we didn't have a picture of it, we lost, which I thought was just infuriating because, and this is 15 some years ago. So yeah, cell phones were common, but not as common as they are now. And certainly picture quality on cell phones wasn't as good as they are now. But that was something that really got me mad because I don't know what more I could have gotten.
Sure.
I mean, we had multiple types of evidence circumstantial evidence, I guess. But it was a testimony from a person who was a witness. So I think that's pretty good evidence. And I lost that trial. It stinks. It was based on comparative negligence that
Sure.
they found that my client's negligence was more than the shop owner's.
Okay, cool.
Yeah.
I
Thanks
guess
for bringing it up. Thanks for ruining my day. Now I have to think about that.
Well, you learned something, yeah. Going off of that, when you have your jury selection and you're picking your jurors voir dire, is there a system you use, or is that just an instinct that you learn through doing cases repetitively?
Is there a system that I use? Well, I like to have somebody with me all the time. So you have either your paralegal who knows the file, or a law clerk or another attorney that can help you watch the jurors.
Watch the faces, sure.
See their reactions, see who they are, and if some counties in Wisconsin give you your jury list a week or weeks before trial, so then you can do some research as to who they are.
A little background research.
What I used to do, because I've tried cases all over the state, I would, in some areas, I would get the jury list and then call up a local attorney and say, hey, can I buy you lunch? And I'd drive to their office and say, here's a list of jurors. Do you know them?
Mm-hmm.
And sometimes it's, oh, yeah, this person's in Kiwanis and that person's a farmer and this person's, somebody who knows them and is really involved would know who they are.
Yeah.
I have that exact story. I went into a law firm, met with all their partners, and for them it was fun because they're like, hey, look at so-and-so is going to be on this jury next week, blah, blah, blah. And they were having fun with it, which was great for me because I got kind of the insider information.
Mm-hmm.
But I think that's something you do with your jury. And then certainly having information about what information meaning, either you do a mock jury or you do something like that beforehand so you have a general idea of who you're looking for, or you run this past other attorneys and you get a general idea of what you're looking for, and go into your jury selection with those criteria, and hopefully you get jurors to talk so you're in a better position to know where they're going to come from so you can select the best jury for your particular fact scenario.
Sure. Then I guess kind of moving more into big picture, in Wisconsin PI, do you think there's been any significant changes in the last 25 years, whether that be, tort reform, damage caps, even insurance tactics? What do you think the biggest change in the last 25 years has been?
Biggest change? I remember, I'm trying to think if it was in 25 years. It has to have been in 25 years. Other attorneys would probably know the exact date, but there was probably about 15 years ago when the insurance limits were changed, down to $25,000 per accident. Oh, you're giving me, okay, sorry. We have 5 minutes to go. Okay. Their insurance limits were changed, and whether you could stack policies or not was changed. So we, meaning a lot of trial lawyers and a lot of personal injury attorneys in the state, had put a lot of cases into suit because of that. So there was that. That was pretty significant. That was under Governor Walker, which would be about probably 15 years ago-ish. That was probably the most, the biggest deal in the past 25 years. Because if we're looking, I've been a lawyer for 26 years now. I'm trying to think initially. Other limits, changes. Punitive damages being limited was certainly pretty important.
Sure.
We used to not have a cap on punitive damages. Now there's, sadly, there's a cap, I would say sadly. Or there's a limit to it. So, but probably under Scott Walker, and I think it was Act 10, where he made changes to insurance limits and reducing clauses, stacking, things like that in general.
Are a lot of those caps kind of born out of insurance lobbying, or what motivates those?
I think they're born out of insurance lobbying. Certainly, I think everything's born out of insurance.
Right.
A certain kind of lobbying. I don't think it. This is my bias. I don't think that they make any sense, given what medical, the cost of medical care.
Sure.
And I think our best ally in this argument are the subrogation attorneys for health insurance, because health insurance gets money back from at-fault parties when you settle or try a case, and that's in theory or in reality a revenue stream.
Right.
You're going to get money for a payment for an X-ray. You're going to get money back from a third party to cover your cost. Well, that's fantastic. So as health insurance, that's fantastic. Well, if there's not enough money to go around from that third party because of low limits, that's going to affect health insurance more so than anybody else because of a thing called the made whole doctrine.
Right.
They're going to, if they are health insurance, they're going to have to take zero as payment in full.
Sure.
So I think it would help victims and help health insurance if limits were higher. And you just look at, again, going back to the cost of medical care, a flight for life can be $20,000 to $40,000, and MRI can be $4,000. PT can be $10,000 for a course of physical therapy. So that together, you are going to get what for the victim if the policy limits are, full coverage of $25,000. There's nothing for the victim. It's terrible. Anyway, so I don't know what the question was, but that was
that was great analysis.
Yeah.
All right. I think we're running out of time here. So final question. Groth Law is currently 16 years old, I believe.
It can drive. Groth Law can drive.
It can drive.
Yeah.
20 years from now, what do you want this firm to be known for?
My gosh. 20 years from now, will it be around? Will the AI robots have taken over?
Maybe.
Or will other law firms, like we just learned recently, sell their in an MSO, be publicly traded, and then just buy other law firms, and then we'll all be part of one big, massive personal injury law firm. I mean, that is so unbelievable that I can't imagine what's going to happen in 20 years. I would hope that we're still around. I would hope that we've created a niche of extremely good service, extremely good advocacy for our clients, that we can't be disrupted. We can't be taken over.
Sure.
That's the hope. That's our goal. But the reality is there's so many factors.
Yeah.
I mean, I'm glad we are where we are in 2026. If you would have asked me this when I was 2L at Marquette Law in 1998, I would have never imagined that I would be here, which is just kind of shocking to me that we've come this way. If you think of all the different decisions that I made over the years that led me to this, it's like, wow, it's just kind of a crazy little maze that we've run through to get to this position. But luckily, we're here.
Luckily, we're here. Congratulations.
Luckily, we're here. All right. Well, yeah, and luckily we have you. So thank you for these great questions.
I'll stay the straight. Don't worry. Don't worry. I'll make sure we go the distance.
Yes, thank you. With your help. All right. That's it for Groth Gets It, the Law Clerk edition. Thank you, Nathan. We will see you next time. I think we're going to have more law clerks this summer, and we'll go from there. All right. Have a great day.